Good afternoon. It's Thursday, June 19th, and I did a video last week or a couple weeks ago, about how people who had asylums pending with USCIS were getting notices of cancellation of their pending asylum and without adjudication, and that then they were being referred to ICE essentially for detention and expedited removal. Essentially, what is happening is that people who have been in the U.S. for less than 2 years, filed I-589s or asylum applications with USCIS, and then USCIS issues a notice of termination of the process, so that ICE can essentially process them for expedited removal. And I got this comment from Shaquille saying, I have already a credible fear interview positive. So he had a positive credible fear interview in a detention center last year in November. And I applied for asylum in January 2025. Does this apply to me? And the answer is no. Why? Because generally, after you do the CFI, and it's a positive CFI, you will be issued a notice to appear in EOIR or immigration court. So your case would not be with USCIS, it would be an EOIR, and because you already have the CFI, they have to proceed with that asylum in EOIR. All right. Now, if by chance DHS gave you a notice to appear or an NTA, but didn't actually file it with EOIR, so you have this paper, but your case doesn't exist in immigration court, then you do file it with USCIS. But nonetheless, yours wouldn't be one of the cases that they would send a termination letter for, because you already have the positive CFI. People who are getting those termination letters usually don't have the positive CFIs. They have to ask for them after they're detained prior to being expeditiously removed, because that's the only thing that will keep them here, is getting a credible fear, a positive credible fear interview. So this is a good question. If you already have a positive credible fear interview, then you're likely not going to be processed for expedited removal.